This presentation is regarding Chapter 8, the legal and non-legal secondary sources. That's Chapter 8 of the Sloan book. There is a reference slide at the end because I did incorporate a couple of three other authors of some textbooks that I think are useful in blending in here. To introduce the topics, these are the points we're going to cover in this presentation. The pre-search filtering, secondary source research defined, when secondary sources will be most useful, the limits on the appropriate use of secondary sources, and popular legal secondary sources. Just a very brief overview of them. To begin with, once you've articulated a research question and generated a list of research terms, the next step in your research is engaging in pre-search filtering to focus your research. Pre-search filtering is when the researcher decides what degree of confidence the researcher has in the subject areas defined in the previous step where you generated a list of search terms for your research. Pre-search filtering is the decision the researcher makes about research strategy. And this idea of pre-search filtering is a topic of Chapter 4 of the Sloan textbook, but Chapter 4 is just a little bit premature for this particular class at this point in the course. So we'll flash back to Chapter 4 soon. But for this module, we're going to introduce the secondary sources. Your ultimate goal in most research projects will be to locate binding primary authorities if they exist. These are the ones that will resolve your research question. And we've already covered this particular ground of binding primary authority in a previous module. However, please note this task of finding binding authorities can really be difficult for the novice researcher, especially when the researcher does not have enough background knowledge of the area of law being researched. And this is where the secondary source research comes in beautifully. Secondary sources are, remember, this is really important, they are commentary about the law. Secondary sources are not the law itself. As such, secondary sources are not primary sources of law, and they are non-binding. This is such an important distinction because a judge does not have to follow the words you read in a secondary source. And secondary sources are not controlling in and of themselves. However, in some situations, as I'll discuss later in this lecture, secondary sources are, to use the term loosely, good enough to be persuasive enough to cite in your writings. But we'll talk about that here in a little bit. What are secondary sources great for? They're great for learning an overview of the law. In fact, your textbooks for this course and other courses you've taken so far, they're all secondary sources of law. Think of these secondary sources that I'm going to talk about in this lecture as being just like your textbook, a good place for an overview and to get generalities about the law, but it's not mandatory law. The sources themselves, the secondary sources, are non-binding and non-controlling. All right, so however, all of this has been said about secondary sources being non-binding and non-controlling. Know that within the writings of secondary sources, there are references to sources of law, commentary about the sources of law, and citations to the sources of law, so that the reader can locate the law cited. So secondary sources are a finding tool in addition to an understanding tool. In other words, the law cited within secondary sources could be primary/binding authority. Of course, you know from the previous lesson, whether the law you find in a secondary source is binding will depend on whether the primary source cited in the secondary source is on point, and whether it comes from the jurisdiction of the claim you're researching. So all of this research into secondary sources requires that you filter so that when you see a secondary source and you look at the law cited within that, that you're recognizing that there may be primary on-point authority that's controlling in your jurisdiction. But that's not always the case with secondary sources. But it is nice to run into those, and it's like, yes, I found something, it's right here. Now I have to take the next steps. All right, so the topics of on point and jurisdiction, that was covered in the earlier module, and if you need to freshen your memory, it's under the Chapter 2 of the Sloan textbook on the American legal system. All right, so listed here on this slide is a list of common legal secondary sources. In a presentation, or in a slide later on, we'll cover these in a little more detail. For now, this is a starting point. And you can also read our textbook in Chapter 8. Right now, it has more detail about the common legal secondary sources used in research. In addition, Introduction to Paralegal Studies, A Critical Thinking Approach, that's the Currier and Eimerman authored book for PLA 1104 course. Chapter 14 has additional information about these types of sources, and I recommend you read it. Many non-traditional secondary sources are also on the internet, and it's important, as the author notes, Amy Sloan, that before the internet, the only secondary sources to be found were found in a law library and stacks of books. And today it's a whole different story. So publications from the government, academic institutions, and legal scholars are everywhere on the internet today. And these non-legal secondary sources that are located on the internet can be very useful sources in terms of using them as a tool that is being explained in this lecture. All right, when secondary sources will be most useful? Well, once you have carefully studied the client's situation and developed your initial research terms and issues, or issue, your next step is to what we call frame your legal research. Although your ultimate goal is to find and rely on legal authority and commentary about the law, legal authority and commentary about the law, again, is not the law. Framing your research can be done, really, needs to be done through commentary for a few reasons. First, commentary, like that found in secondary sources, will provide you with an overview of an area of law. And without this overview, you may not see the proverbial forest for the trees. Second, commentary provides references to legal authorities. It identifies some of the major tenets of the ultimate legal research goal. So again, back to the concept, we're framing the legal research. And third, commentary sources are pretty much a lot easier to research in and understand during the early stages of your research than to just sit down to the law itself, which can be sometimes hard to understand, hard to read, and hard to grasp what's going on in a case or a statute, which can be very, very difficult to read. A treatise, for example, is a secondary source, and it's much easier to read than a statute. A restatement is a secondary source, and it's much easier to look at common law principles in a format that sort of resembles a statutory format. So we'll get to that in a little bit too. When researching in an unfamiliar area of the law, secondary sources give you the necessary background to generate your search terms. In our previous assignment for this course, you were asked to use a thesaurus and a legal dictionary in terms of finding new research terms. A thesaurus and a legal dictionary are secondary sources. They're at the lowest level of secondary sources, but they are in fact secondary sources. So when you're unfamiliar with the law, you can go to a secondary source to help expand your research terms. And other secondary resources can also do the same thing. If you need to find non-binding primary authority on a particular legal subject, doing the research yourself can be a daunting and time-consuming task. For example, I frequently, as a faculty, use secondary sources when teaching subjects of different legal subjects that I need to convey examples of, and give case law that provides examples of it. I think family law is one of those areas that I've probably utilized it the most in teaching here at SCF. Secondary resources in family law, someone has already combined all of the law about family law, and so alimony support, um, uh, things like property distribution, and those kinds of areas. I can more easily and quickly find some secondary authority on it that says, Smith versus Jones, or Smith versus Smith case, in the Second District Court of Appeals in Florida. The court said this about said this was the ruling about property distribution or alimony or whatever. So I can apply those. In other words, what I'm trying to say is that non-binding primary authority on a subject can be found, and binding primary authority on a subject can be found. But when I'm trying to just convey information that's relevant to a Florida student in a family law class, secondary sources can be a huge time saver. And it can be for you as well as a researcher, because you can get the general idea and know where to go next with your research. If it wasn't for secondary resources or sources of law, it is one of the first places I turn in my research, and it always has been, even when I was a paralegal and trying to research for attorneys. I often began with almost 90% of the time began with secondary sources or statutes if I knew it was a statutory question. All right. Also, as noted in the fourth bullet point on this slide, when researching a question of first impression, secondary authorities can help you with the discussion that you're writing about in terms of how it should be analyzed. So if it's undeveloped area of law, it gives you the opportunity to see how other scholars believe it should be analyzed. So again, to help you with your research and develop a strategy. Again, that's what secondary sources will do for you. It's not just about a finding tool, but a strategizing tool. And when your research comes up, when you come up with too much or not enough information, secondary sources can educate you on the subject matter and help you expand and refocus your research efforts. Many times I have used secondary resources to help me find the most commonly cited cases on a subject. And so I'll maybe research and find 2 or 3 secondary sources on a legal subject, and then not oddly, it just automatically happens that the same case names appear over and over again. So I've often found a nice little treasure that helps me focus my own research and leads me to a better result for my research question. Okay. Limits on the appropriate use of secondary sources. I've already, this bulleted list, I'm going to explain a little bit more. As I've already discussed in a previous slide, secondary sources are non-binding. The source itself is non-mandatory source. Sloan, the author of our book, also notes that you won't ordinarily cite them in your written work. So when you're writing a memo or whatever you're writing, you normally do not refer to secondary sources. When you use secondary sources as a finding tool, you may eventually find a primary binding source. And then you would read that source, and you could cite that source in your written work. It's important to read the primary sources you find in a secondary source to avoid plagiarism, and importantly, to avoid the chance that the commentator or the author of the secondary source might be wrong in his or her analysis. So it's just like anything else. Even if it's written and it's a highly regarded secondary source, you've got to make sure that it's correct. So it's a beginning place of research again, not an ending place. Also, secondary sources, they're not updated like primary sources are. We'll cover the idea of updating your research to make sure the law is still good in a later presentation, or later on in the course. But one mistake some beginning researchers will make is citing to a secondary source for the text of a case or statute, and then not make sure that the case has not been overturned or that the statute hasn't been changed. So again, you still need to go to the primary source you're led to and not cite directly to the secondary source until you, and again, use it as a finding tool, not as a tool to cite to the courts or in your memo. However, one thing that's true is, or a few things that are true, is it must, some secondary sources, such as treatises and restatements, are highly persuasive, all right? And I mean, a legal dictionary is not highly persuasive. It carries only as much weight. It is what it is. It only carries as much weight as it carries. It's a definition, good job, all thumbs up, but you wouldn't want to cite to that in your writing unless you had no other options. But some of these, like treatises and restatements, carry a very high persuasive power. Power isn't the right word, but it's a source that's highly respected. Prosser on torts, for example, is a treatise highly respected because of its authorship. It's still not mandatory or binding, but it does lend a lot of credibility to an argument because of the expertise of the authors of the book. Nonetheless, it's critical to make sure there is no primary source to cite that says the same thing as the treatise or that says something different from the treatise. You can't make up a story. You just have to do what the law says. Precedent is precedent, and a treatise would not overcome a precedent value. It might persuade the court to change something, but that's it. If you use a definitive treatise, for example, Prosser on torts, you might cite it in your writing, but ordinarily you would use treatises and other secondary sources for research purposes and not cite them in your written analysis. So they're non-binding. Don't cite directly to secondary sources unless you really thought about it, and always look for the primary source that's being handed to you or given to you in the secondary source, because the primary source is going to be controlling and those are the benefits that you must have in your writings. All right, so some popular legal secondary sources. This slide will take a minute or two, or a few minutes. There are some listed here: the legal encyclopedias, treatises, etc. Legal encyclopedias are organized by topic. For example, animals, criminal law, contracts. They cover general subject matter, and they often cite to seminal cases and additional secondary source materials about the subject. In the United States, there are two major national level encyclopedias. One is American Jurisprudence. We also refer to that as AmJur. And the other one is Corpus Juris Secundum. We call that CJS. These are national encyclopedias, so the generalities are going to be on a national law level. I might find a case from Florida used to describe, or used in the commentary in one of these dictionaries. However, these encyclopedias. However, it's important to note that it is very national level, and it is an attempt to generalize throughout the United States areas of law. That's what a legal encyclopedia does. We also, in Florida, we have our own West published legal encyclopedia called Florida Jurisprudence, and we nicknamed that FLA-JUR. So we have three little pieces of jargon you'll learn here in this presentation. One is AmJur and CJS, and the other one is FLA-JUR. And now you know when someone says that what they mean. Other states have legal encyclopedias as well. Treatises, the next one on the list. These focus on subjects that it gets more narrow than the legal encyclopedia. That's why they treat it after encyclopedias. There'll be very in-depth treatment of a single subject, such as contracts, torts, constitutional law. As the previous slide I noted, some treatises are widely respected and considered definitive sources in their subject area. Prosser on torts, Corbin on contracts, Wright and Miller on federal civil procedure. In Florida, we have Trawick, spelled T-R-A-W-I-C-K, on civil procedure. You may have used that in your civil procedure class. So again, there's some national level, like the encyclopedias I was talking about, and there are treatises that get highly specialized, more narrow in focus, both nationally and state organized. And they get very highly specialized, like, what's an example? Copyright, a treatise on copyright. Legal periodicals, the next one on the list, they're often called, well, two things really fall into this category: law reviews and journal articles. And these are law reviews, law reviews are published by law schools, and they collect articles on a wide range of topics. They are written by judges, professors, law students, and others that they invite to write in the topical area that they're wanting to cover. There are also some commercially produced legal periodicals, such as the ABA Journal. Law reviews are extremely beneficial when you're researching an area of law you're unfamiliar with. They are written by top law students, judges, practicing attorneys, professors, and they often have a little introduction of the topic at the beginning. For the most part, you will use the periodicals, like the ABA Journal, to deepen your understanding of an issue, and rather than as support for written analysis. And the same is true of periodicals like law reviews. If you can't find primary authority, you can cite to legal periodicals, but remember, it is merely persuasive, and legal periodicals, you would have to know how to, think about how to judge the person that wrote it. If a judge wrote it, you might have more persuasion than if a law student wrote it. Does that make sense? Legal periodicals are available on many databases. Some law schools have their law reviews available on their college website. Databases in the SCF library include many law reviews. I've used JSTOR database for law reviews a lot in my research, and that is a database in the SCF library. And there are some others. Journal articles are easily found on the internet, and like ABA Journal, portions of it are available to the public. Other portions of it, you would have to have a subscription fee. American Law Reports, the next item on the list, we call this ALR, includes annotations of cases. Annotations are an important word for legal researchers. Annotations are editorial features of legal publications. They include like court decision summaries and references to other sources of information. These are all added by the editor. If we're looking at annotated statutes, we would see some annotations, which are editorials, added by the editor. If we were to see, in this case, ALR, it is an annotated, they are all literally summaries of cases on many given topics. These are more detailed than encyclopedias. However, they mostly report the results of the cases without much analysis or commentary. ALR is helpful in directing you toward binding or non-binding primary authorities, cases obviously, to read in your research. Restatements. The American Law Institute publishes what are called restatements of law in a variety of fields. Restatements essentially restate the common law rules on a subject. So this is great. Restatements are a great tool for times when you need to know common law doctrines and rules. Restatements can also provide commentary on common law rules, and they'll illustrate how the rules apply in certain situations. It carries substantial weight as a secondary authority. In fact, restatements are the most citable form of commentary in terms of citable in your writing. Courts sometimes use restatements to build the law on a new subject in their own jurisdictions. Sometimes adopting rules and even incorporating illustrations from restatements into their decisions. So that's a really quick and very distilled overview of these particular secondary sources. I invite you to read a little bit more about them in the textbook, and also in the Currier and Eimerman Introduction to Paralegal Studies book. They'll have some more details in there as well. But in a nutshell, secondary sources are great tools for understanding the law, finding primary law, improving your search terms, and sometimes for citing in your writings, and you need to use true caution when you do. Some excellent sources that are available, those listed in the previous slide, they're a great source for beginning your research. They're a great source for building your knowledge in an area. I bring this to you early in the semester. We're going to work with them on some electronic basis, and I bring this to you early in the semester so that you can learn to attract yourself to these and not take the approach of I need to find a case on a topic of law that I know nothing about when these secondary sources are available to you. To conclude, these are the topics that we covered. And then finally, there's a references list here. I found some great add-ins for this particular lecture today from some other sources like the Currier and Eimerman book, a couple of others that are probably not available to you except if you were to call the publisher and get a copy. But the Sloan book, of course, was included. All right, that's it for this lecture, and thank you very much.